bathroom was part of the same accommodations. In the case at bar, the office is a separate, detached structure. And furthermore, in U.S. Pena, the defendant was present and in the hotel room. Thus, and he was watching the search go on in front of him. Thus, he had the opportunity to stop the search from occurring, yet he allowed the search to continue. And in the case at bar, my client was not even aware that the search of her office, her personal space, was occurring, given that Detective Eisenberg didn't even tell her that Desi consented to the search, and Detective Eisenberg knew that my client was the one with the key. Furthermore, the people bring up USC Matlock to argue that Desi can give consent. However, USC Matlock deals with a common area. And in the case at bar, we are dealing with a personal and private area of the office belonging to my client. And all the memorabilia inside said office show that it belongs to my client. And furthermore, USC Matlock brings up that narrows the co-occupant's consent to state that they must have joint access and control. However, in the case at bar, Desi's joint access is limited. And she has no control whatsoever over the office. She does not have a key to said office.
30 seconds.
And furthermore, they bring up Illinois v. Rodriguez. However, Illinois v. Rodriguez is distinguishable given that Fisher had a key. And furthermore, he claimed to live in the apartment. And in the case at bar, Desi did not claim to have control over the office whatsoever. And Detective Eisenberg's belief was unreasonable. For all these reasons, Your Honor, the defense respectfully requests that the court grant this motion. Thank you.
Thank you very much. For the prosecution.
Yes, Your Honor.
Your Honor, the defense fails to understand that just because Bailey has a key to the office does not mean that Desi does not have joint access to the office. And that is seen through the exterior door. Like, she may enter the premises. And we see this earlier on later on in the case, where Bailey forgets her keys to her car, right? But that does not mean that Bailey does not own the car. In this case, just because Bailey has a key to the office and Desi does not have one on her, does not mean that she never has one, or that she never has joint access to this room. Also, the defense also forgets the fact that an office can be used by whomever and can be owned by whomever. Because of the fact that the office is right next to Desi's living quarters, means that it's more likely that at the very least, Desi has joint access to this office. It makes much more sense that an office which is connected to a guest house, which is a detached building, not the office itself is a detached building, is where Desi resides. And as such, when asked if he may search the guest house, which is the detached building, which includes the office, which is right next to Desi's living quarters, it is reasonable for Detective Eisenberg to believe that the office belongs to Desi. That's all.
All right, thank you. Appreciate it. All right, so now it's time for the ruling on this matter. Obviously, by design, this is something that they construct to be a close call, one that could go either direction. And I guess a little ironically, it's a little more, even more difficult to rule on something like this in this setting than in an actual case where on a motion such as this, you would have the detective would come and testify and potentially other witnesses, and so you get to see the reaction of the witnesses. You can get a better sense that typically you will get more information, so a little ironic there. But my ruling on this is going to be that Bailey's consent to search included the search of the office, so the defense motion to exclude that will be denied. The exhibit and the bracketed portions will be permitted. And the brief explanation for that is that, again, I think through the consent to conduct the search, I think it is a reasonable, objectively reasonable interpretation that would include Desi's office. The information available to the detective was that was Desi's office. So Desi's consent was to search the house, search the garage. There was no exclusion of it. As indicated, the evidence showed that it was his office as opposed to Desi's office. I think there's no need to get to the issue of Desi's consent, but I think that for me, the issue of Desi's consent would go the other direction. I don't think that Desi's consent would be sufficient but for we already have Bailey's consent, given that the only access to that office for Desi was for work-related purposes, and it was all he's indicated he always he or at least customarily had to go get the key to use it. So I think some of those facts point to Desi not having the authority to consent to it. But like as indicated, my rule will be that Bailey's consent did extend to the office, and therefore that exhibit, the one page from the script, will be permissible for use, and the bracketed portions of the witness's statements will be included as well. So with that, then we will move along. Then do we have any physical evidence? Have we already taken care of the physical evidence to be inspected, and any issues or objections we need to address relating to the physical evidence? Okay, perfect. Thank you very much. And do the parties waive the reading of the stipulations? I'll save ourselves some time so we don't read the stipulations. We will still stipulate to that. We will then have a reading of the charges is that the people of the state of California are charging the defendant, Bailey Matsumoto, with murder, which is the unlawful killing of another human being with a malice aforethought. So with that, we'll go ahead and switch out, and we'll get to the opening statements, give you an opportunity to switch your positions.